Thank you everyone for joining the webinar today. My name is Michael Hansen, Program Manager with the Action Innovation Network. Action is a collaborative network of technology business incubators and entrepreneurship support organizations located throughout the New England region. Our network supports startups developing innovative technologies across a wide range of industry sectors, including life sciences, clean energy, blue tech, robotics, advanced materials, and others. Our Plymouth Rock project provides a suite of resources for international startups that are interested in exploring this innovation ecosystem as a place to grow their company in the US. Please submit your questions using the chat window anytime during the presentation. There will be time for questions and answers at the end. This webinar will be recorded and emailed to you and also posted on our website for future viewing. Today's webinar is presented by Aaron Blumberg, Brian Doyle, and Irma Dias with law firm Fragomen. Fragomen represents a broad range of companies, organizations, and individuals to help facilitate the transfer of employees worldwide. The firm provides immigration support in more than 170 countries. An AM Law 100 and Global 100 firm, Fragomen's professionals are respected thought leaders in the immigration field, as recognized by Chambers, Best Lawyers, and Who's Who. The firm employs more than 4,400 immigration professionals and support staff located in over 50 offices across the Americas, Asia Pacific, Europe, the Middle East, and Africa. Its professionals contribute to conferences and seminars around the world, author respected publications, and have years of experience working in government agencies and in-house corporate immigration departments to advance world-class compliant immigration solutions. Thank you for joining us today, Aaron, Brian, and Irma. We look forward to your presentation.
Great, thank you, Michael, and thanks for the warm welcome. My name is Aaron Blumberg. I'm a partner at Fragomen, and as Michael mentioned, we are an immigration law firm, and in fact, we are the largest and oldest immigration firm in the world. And that's really all that we do. We specifically practice corporate immigration, which means that we help companies looking to open up and hire individuals in the United States. We help students and recent graduates looking to be employed and get a work visa in the United States. And we also have global offices that help individuals looking to immigrate to other countries outside of the United States. So today, of course, our focus is going to be on US immigration options for startups. And I'm joined by my colleagues, attorneys Brian Doyle and Irma Dias. And I think a lot of you listening today realize how difficult it's been over the last 2 years, and especially with immigration, with all the travel bans that we've seen and the changes. You know, there's a travel ban one day, and then there may not be a travel ban, or it may be from one country and then changes to another country. So the restrictions on travel and entry to the United States have been complicated, ever-changing. And we're finally starting to get to a little bit of a better point. We thought we were in the clear, and then there was another travel ban just added for some Southern African countries just about a week or two ago. But otherwise, for the vast majority of the world, things are opening up. And with that being said, I want to turn it over to Brian, who's going to start our discussion today. And I'd like for him to just talk a little bit about non-US startups and some of the challenges that they face and some of their options for bringing talent into the United States and really starting their business in the United States. So I'll let Brian take it away.
Absolutely. Thank you, Aaron. And thank you, Joan and Michael, for having us this morning. Happy to be here to talk about this. So where we're going to start is, looking at it from the perspective of folks who are outside the United States. You've started your business, you want to get into the US market. How do we go about doing that? How do you get your foothold in the United States? And how do you get your talent into the United States to sort of get into that market? Now, a lot of us over the last 2 years now with COVID have not been able to travel to the United States. Maybe you're a year or two into your startup and you've had to postpone, the strategy of getting into the U.S. market. So what I'm going to talk about is essentially the options, specifically the U.S. visa options for getting into the U.S. market for those of you outside the U.S. right now. And this is going to be true whether you're in the UK or France or India or China. A lot of these visa types will be available no matter where you're located right now to get into the US. And really the top option, or sort of the most likely option for folks to get a foothold into the US, to open a new office in the US, and to get your existing employees into the US is going to be what's called the L1 visa type. So an L1 is what's called an intracompany transferee. So this is a US visa type that allows an entity with a location outside the United States to transfer its employees to an affiliated entity, whether it's a subsidiary or a branch or a joint venture located in the United States to work there. One question that often comes up is, all right, I'm in France and I want to get into the US market. What type of entity do I have to have in the US for this type of visa? And it really, for the most part, can run the gamut. It could be a sole proprietorship. It can be a subsidiary. It can be just a branch office being opened in the United States. There's a lot of flexibility on that front in terms of who would then be eligible, or whose employees would then be eligible for the L1 visa type. But what is important is that there is a qualifying relationship between a US sponsoring entity and the entity outside the United States. What we mean by that is going to be typically ownership and a greater than 50% ownership in terms of common ownership between these entities. In terms of looking at who can actually be transferred to the United States, there's two different subtypes of the L1 visa. There's L1A, which is for executives and managers, and L1B, which is for specialized knowledge workers. So when we're looking at each of these visa types, executives and managers, it sounds a little bit more straightforward. We kind of see an executive and we know an executive. We kind of see a people manager with direct reports and we understand what that is. But there is sort of specific criteria that has to be met in terms of establishing this to obtain a US visa. So for example, people managers need to have direct reports who are what's called professionals. So basically typically degreed individuals, not first line managers, maybe much lower in an organizational chart. There is also the opportunity to have non-people managers, what we call sort of a function manager. So someone who maybe is in charge of a large sort of programmatic function within the organization. Maybe they don't have direct reports, but they have a key managerial duty in terms of what they do for the organization. So that's always going to be that sort of one subset. The other subset in the L1A visa type is what's called a specialized knowledge worker. And that's really a term of art. You can say, what is specialized knowledge? And, it's defined in regulation as basically being someone with knowledge of techniques, proprietary tools, proprietary knowledge of the organization that maybe folks outside the organization do not have, or it takes significant ramp up time for you to train someone to have that knowledge. And it's knowledge that gives the organization, a competitive advantage in the marketplace and the global marketplace. So that's always going to take sort of a specific look at what the employee does, what the employee's background is, what their experience is, in order to determine eligibility for this visa type. Now, to be eligible for an L1, the employee does have to be working for an entity outside the United States for at least one continuous year out of the preceding 3 years before trying to come to the US. So they do have to, establish that they have experience with the foreign entity before coming to the US, be working for the foreign entity before coming to the US, because it is an intracompany transferee. One important thing to understand, especially in the context of international startups or non-US startups, is you can get an L1 to open a new office. Okay, so you might not have any footprint yet in the United States, and you want to transfer an executive or a manager to the US in order to get things up and running. Now that is feasible. You can do that, but there are some additional requirements that go into that. For example, actually having physical premise. So just having an agent and creating an entity in the United States by itself is not going to be enough. Typically you're going to have to show that you are operational, you have a lease somewhere for your office space or whatever it might be where the individual is working. And then you also are going to have to show that you will be operational up to speed within a 1-year period, that you'll actually need someone in a managerial capacity in the US within a 1-year period, and that individual is given the L1 for a 1-year period. So sort of a shorter than the usual, what would typically be a 3-year period in L1 status. So it is a feasible option, especially in startup context, for getting into the US market and getting important folks to the US to get things off the ground and running for a US entity. In addition to that, there are other things that come into play. One often question that we'll see is, okay, I am an executive for entity A in France. I need to go to the US, but I'm still going to be based in France. I don't plan on and moving to the US full time. Well, there is the possibility for what's called an intermittent L1, where you are doing executive work or managerial work in the United States for a US entity, but you are only doing it, maybe for a month at a time, or you're coming 1 week per month over the course of a year. That is an option for folks. There isn't the requirement that, there is a requirement that you're working full time in the US, but there isn't the requirement that you're moving and being full time in the United States in terms of your employment. The other question we often see is, can I stay on foreign payroll? I'm working for company A in France. I am going to come and work with our entity in the United States. Do I have to be transferred to that US entity in terms of payroll and the like? And the answer to that is also no. As long as you are working and sort of controlled by the US entity while they're there, you can remain under foreign payroll in this context. For folks that are going to transfer full time, they're going to move to the United States. They're going to be working in the United States sort of on a more permanent basis. And L1A executives and managers are limited to 7 years in that status, and L1B specialized knowledge professionals are limited to 5 years in that status. But again, these rules don't apply to that intermittent L. So you're coming and going between the U.S. and wherever it is that you're based. Those limits don't apply in that situation. One other thing to keep in mind is, okay, I want to transfer my employee to the US, but they have a spouse, and will their spouse be able to work in the United States? So L2 is a spouse visa for someone in L1 status, and dependents are able to obtain work authorization through having L2 status. There are some other considerations right now, and this could be very temporary. Those spouses have to apply for a work authorization document, which can take some time to get. But in the near future, they should just be able to work just upon entering the United States without taking an additional step to get a work authorization document. So always important when discussing with employees, well, can my spouse work? That's going to matter in terms of whether or not I go to the US, an important consideration to think about. I do want to talk about some other options that exist. Another is what's called the E2 Treaty Investor Visa. So you always have to be very careful in giving a general overview of the E2 visa type, because it's based on treaties between the United States and other countries. And there's 50+ treaties, and there are country-specific requirements in terms of who can obtain an E2 visa. It is country dependent, but just generally speaking, there's sort of two things that we're looking at: the actual treaty investors and actually the employees of treaty investors. So the first thing is looking at, a treaty investor is basically going to be a company that wants to get into the US market and is investing substantial capital in the US in order to do that. And this needs to be sort of at-risk funds. It needs to actually be sort of a true investment, and with the purpose of entering the US to develop the enterprise there and direct the enterprise there. A treaty investor is going to have to be a national of the same country, meaning the company needs to be basically national of the same country where the treaty takes place. At the same time, there's also, the employees of this company that is trying to get into the United States. So say, you are a UK company. There is a UK treaty with the United States for E2 treaty investors. You're a UK company, you've now started in the United States. You want to get your employees into the United States through this E2 visa type. You can do that, but your employees are going to have to be the same nationality as your company. So say you're a UK company, you have a UK employee, that person very well may be eligible for E2 visa type, but your UK company with a French citizen employee, they would not be in that situation. So this is available for executives and supervisors, or what's considered an essential employee that has special qualifications that render them essential in the United States. Again, it's important to talk to an immigration attorney about the E2 visa generally, depending on where you're located and the citizenship of your employees, because each treaty has specific requirements. For example, the UK requirements go above and beyond having to be a UK citizen. You also have to be domiciled in the UK. So, for example, the UK, the sun never sets on the British Empire, as all these Commonwealth countries. I'll occasionally see someone say, I'm a UK company, I have this UK citizen, but they're in New Zealand working right now, and they've worked there for the last 5 years. Well, that's a problem for the E2 visa type for the UK, because they're not domiciled in the UK. They might have almost no ties anymore, and we have to look at other visa options. So in terms of the E2, this is a good understanding of what the requirements are, but country-specific concerns and issues can come into play as well. And then just quickly, the last, potential option that I want to talk about, among others, but that I want to talk about in terms of, startups that are outside the United States for getting talent into the US is going to be the O1 Extraordinary Ability Visa type. Again, we're mostly going to be looking at that in sort of the science and business aspect of the O1 visa type. It's essentially it's going to be, a very high threshold to meet. It's going to have to be very special employees that have risen to the top of their field and that basically have sustained acclaim and recognition of achievements in their field. Now, there's basically 7 or 8 criteria that exist, and it's sort of like a choose your own adventure in terms of what's required. There's basically 7 or 8, check boxes that you can check off of. You have to check off 3 of those to be eligible for an O1 visa type. But again, it's not going to be for your average employee. It is going to be very, very specific to someone who's very well recognized, someone that whether it's patents or it has a ton of written publications and is very well known for whatever it is that your organization is doing. That's going to be a very specific visa type in terms of what could potentially be used to get someone to the US. I want to pause there for just a second, because I think it's also important to talk about what potential options might exist for you once you're already in the US. To sort of attract and have local talent, what other options might exist. So Aaron, I'll turn it back over to you to move forward.
Sure, thanks, Brian. And actually, before we get there, we had to have some really good questions about the L1. And so the first question is, what's the easiest type of entity to set up in the US for L1 visa in terms of time and overall cost? Or setting and maintaining?
Yeah, sure. So that's a really good question. And the one thing that I will say from the immigration perspective, just going back a little bit to what I discussed earlier, is it tends to not matter from the U.S. immigration perspective. Talk to, certainly speak with someone who is an expert in whatever locality, whatever state you're looking at in terms of business formation, and what might be the least expensive option and what might be the best option for that specific locality. From the U.S. immigration perspective, from the L1 perspective, we're looking at, again, the rules let you have a wide array. So it doesn't actually matter as long as we can establish the relationship between the U.S. entity and the foreign entity. And again, it can be branch, affiliate, subsidiary, as long as there is that common ownership and common qualifying relationship between the entities.
Yeah, thank you. Yeah, so and just to add to that, whether it's a corporation, an LLC, an LLP, for immigration purposes, it doesn't really matter. What matters is that the shared ownership and that the entities are connected. Then the next question is a good one. So the L1, and just like a lot of immigration regulations, were written a long time ago, and some things don't really apply right now. So one question that a person asks is about the physical office, which, yes, that is still a requirement even in 2021, but could it be a shared office space is what this person is asking.
Yeah, so what needs to be shown is, and typically, as a baseline, a lease would be sufficient for showing, a physical premises. There needs to be shown that there is somewhere where the business will be up and running and functioning. And, I think it's important if we're talking about like WeWork versus, are we in a shared office building with common space? In the end, it is, as Aaron has said, regulations are what they are and times change. As long as you're able to establish that you have that footprint and that foothold and a space and a premises where you are going to be functioning and working and having the business up and running, that should be sufficient to meet what is required under the rules. Certainly the rules are written without 21st century developments in mind, but certainly there's no hard and fast rule about what having a physical premises or what having an office might mean as compared to what we conceptualize it as now.
Perfect. And then there's two more questions, and they're quick, so I think I'll take them. One is asking about the prior employment abroad. Could you be a contractor? And no, you would have to be an actual employee for at least 1 year abroad in order to be transferred to the U.S. entity. And then the last question is about what are the requirements for an L2 spouse to obtain a work permit? And as Brian had mentioned, there's a new rule that's starting very soon, possibly within days or weeks. As soon as an L2 gets off the airplane and lands in the US, they're going to be able to work immediately. And the only requirement is that you're married to someone on an L1 and you enter on an L2. It's going to be as simple as that. So with that being said, as Brian had mentioned, I think that the next big element of the immigration puzzle that we want to talk about is what happens when you're now established in the US and you are looking to hire foreign talent, but that foreign talent is already here in the United States, but now potentially needs a work visa or work authorization in order to start working for your company. And this is often the case we see with students, with exchange visitors, where they come and study in the United States. Maybe they have an opportunity to do an internship. You like them, you want to hire them permanently. Well, what do? What are your options? So I'm going to turn it over to Irma. She's going to talk a little bit about your options in these scenarios.
Thank you, Aaron. And thank you so much to Michael and Joan. So excited to be here to speak to all of you. The most common trajectory for immigration processes here in the United States is what you see here, where employers are looking for oftentimes entry-level employees. And where do they go to find this talent? They go to schools, they go to universities, they go on campus, or they invite individuals to learn more about their organization. So again, the most common trajectory actually is with students, F1 students who are either still in their program or moving towards a work authorized capacity. And F1 students are essentially foreign nationals that are studying in the United States. And the F1 visa, which is where the F1 comes from in terms of the regulation, is available to individuals entering the US for academic studies. And there are a plethora of options here. It could be from elementary through postdoctoral education. It does require that the student be full-time and at an approved school. Once you're actually admitted into the United States in F1 status, you are admitted for what they call a duration of status, meaning there is no specific period of stay, and the student is actually admitted through the duration of their academic program, and if eligible, plus additional time in a work authorized capacity, often known as practical training. It's important to note that these students do have a 60-day grace period following the end of their program. But the important thing to note for F1 students is that their stay is actually managed by the Student and Exchange Visitor Information System known as CVIS. And so that program is actually a web-based program that's overseen by ICE, Immigration, Customs and Enforcement, and actually tracks the students and their eligibility to remain in the United States. So oftentimes students that are seeking employment with whether it be a startup or a larger organization, they need to show that they have work authorization to begin working for that company. And so to do so, there are a few documents that the student has to provide. But before I get to that, something also that's noted as super important, as Brian mentioned, is when you're hiring an employee, it's important to consider their family and the individuals that would be joining them or remaining here in the United States. And so F1 students do have the ability to have their family join them here in the United States, and their dependents are actually granted F2 status. So moving into how can you hire an F1 student? And so the more traditional options that exist for this category is first optional practical training. And that can happen before or after graduation, but the field in which the individual is working in has to be related to their study. And you are given a 12-month period of authorized stay per degree program. And oftentimes you'll see that when you're hiring a foreign national, they may have had their US bachelor's degree, and they've had time in OPT, and then they're actually in a master's program or had just wrapped up a master's program, and they are entitled to have another 12-month period of OPT. And so that optional practical training can be demonstrated through a work authorization document called an EAD, or an employment authorization document, and a form called I-20. And that's usually endorsed by the actual school in which the foreign national obtained their education. That work authorization and that endorsed I-20 form is evidence that they're authorized to work in the United States, and you can actually hire them with those documents. The EAD associated with that OPT is not actually tied to any particular employer. The only requirement is, again, that the work that they are to perform is related to their study. And for some individuals that have graduated and had completed a program that was in the science, technology, engineering, and math, also known as STEM, they may be eligible for a additional period of work authorized capacity with a STEM extension OPT. And that actually provides you with an additional 2 years, a 24-month OPT extension. So in reality, if you're hiring someone, for example, that has a degree degree in biology, and you're a company that is in the biotech space, or the role itself is actually related to biology, then that individual could potentially work for you in F1 status under OPT for 3 years. So it actually gives a lot of flexibility, not only for the student, but for employers who are seeking either entry-level positions or students that are kind of geared to those fields. And again, the common trajectory is looking at these entry-level younger applicants through the F1 program. Another way to actually have work authorization in F1 status is something called curricular practical training, which is available as part of the education program. Can be seen when someone is still within their program and they're working for a short period of time, oftentimes no more than a year, or in some instances you will find students that are actually in a master's program, and that master's program offers what we call day one CPT, which means on the very first day of your program, you're actually given work authorization and can work while you're going to school. You do need to show an endorsed I-20, and in this instance, there wouldn't be a separate employment authorization document that the foreign national would present, but still is authorized to work pursuant to that endorsed Form I-20. Another option that is less common than the F1s, but certainly a great option for employers, is the J1 exchange visitors program. And it really is an exchange program because the goal of that program is to allow individuals to not only gain experience or study or do research in their fields, but it's a cultural program to get to know the United States, immerse themselves in our culture. And so this visa category actually comes with several subcategories, such as trainees for people trying to get additional experience, interns, teachers, professors. Oftentimes it's associated with au pairs. I think that is probably the most recognizable category for those who are not well versed in immigration. However, all of these subcategories have requirements and have specific criteria that you actually have to demonstrate before hiring an individual in J1 status. All J1s are sponsored by an exchange program through the Department of State, and similar to the F1 program, they're also tracked in the SEVIS system. And depending on the subcategory that you're in terms of a J1 program, the work authorization period for an individual can be several months to up to 5 years. There is a grace period once your work authorization period has ended, and that is 30 days, which is a little bit shorter than the F1 students. However, similar to the F1 students, you can have dependents join you under a dependent status called J2. So it's something that is actually a really great use of the J1 program. And for example, a lot of companies in the area look to J1s, particularly for those who are doing research in the field. So that is oftentimes a great category just because you can get up to 5 years of work authorization. In J1, change of status to other categories, and we'll cover those categories shortly, is permitted. However, one caveat to this visa program is that some of these individuals are subject to something called a 2-year foreign residency requirement, which essentially means that they would have to return home for 2 years after the completion of their program. And again, it doesn't apply to everyone. This is something that you can see on the form DS 2019, which is the form associated with the J1 program, and it would indicate there or on the J1 visa whether someone is subject. And you may even ask who would be subject to something like this where you have to actually return home for 2 years. Those that are actually subject to that are those that may have come to the United States on US or their home country's government funding. Their field could be on something called a skills list that's produced by the State Department, which indicates that that individual home country needs these skills and are either understaffed or having trouble filling those services. That could, an example could be like a nurse. That area may be in demand for that particular country. And also individuals receiving graduate medical education or training may also be subject to this 2-year foreign residency requirement. There are options to waive the 2-year foreign residency requirement. And so if that's something that you encounter, that is, there's a way to apply for that. And there are different criteria in which you can actually apply for the waiver. And then once that waiver is approved, then you are permitted to change to another classification for work. And the most common and probably the most desired of the visa categories for foreign nationals in the employment-based sector is the H-1B visa. So the H-1B category is actually open to professionals working in a specialty occupation. What that means when we use the word professional in the immigration setting, we're referring to individuals and roles that require at least a bachelor's degree or its equivalent to perform the role. So it wouldn't be a role in which you would only require a high school diploma or would require like an associate's degree. So it has to be in a specialty field related to the work. For those who are educated abroad, immigration has a rule in which the equivalency can be obtained to make sure that we actually have someone with the equivalent of a US bachelor's degree. And where they don't actually have formal education or sufficient education, the 3-to-1 rule allows for someone to equate 3 years of related work experience to 1 year of actual university education. So if someone doesn't have a traditional background where they have a 4-year degree from abroad, but they have relevant experience, we can seek to get an equivalency using that 3-to-1 rule. The H-1B cap lottery is quite controversial because it's something that when you're actually hiring new employees, particularly in the F1 group, they're asking, are you going to sponsor me for an H-1B? And the reason why they're asking is there are several advantages of being an H-1B holder, but you do have to go through a cap lottery. So essentially that cap lottery only provides 85,000 slots per year for H-1B. And normally we're seeing applicants in the 200,000, 300,000 range. So there are more applicants than there are slots. And 65,000 of those slots are just standard H-1Bs that are related to those that have a bachelor's degree, and the role itself only requires a bachelor's degree in a particular specialty field. And there is a what we call master's cap, where there are 20,000 spots or slots that are set aside for those who have an advanced degree from US universities. And so those that are in the master's cap actually in some ways have 2 bites at the apple. They're much more advantageous for those who are actually completing master's degree programs or doctorate programs here in the United States. And so they have a slight advantage over those who do not have a US degree at that level. And the benefit of having an H-1B is that it provides a 6-year work authorization period. And there are opportunities for those who are from what we call backlog countries, or countries that have a high population of immigrants immigrating to the United States. You can actually, in certain circumstances, extend your H-1B beyond those 6 years if that individual is pursuing a green card process, or what we call permanent residence. And it definitely is, I would think, the most versatile and most appealing of the visa categories, because it is valid for a 6-year period, and it has something called dual intent, which allows you to pursue a green card process while maintaining an H-1B, and many categories don't give you that option. The H-1B also has the ability to provide status to family members. And of all the categories, I will say that this is the most pressing of the issues for H-1B holders. They really, really want to know if you're getting sponsorship, but they also want to know if their family members will be sponsored. And so dependents of H-1Bs are called H-4 holders. And the benefit of being an H-1B and also applying for your H-4 spouse is that at some point in the process, you may be eligible for work authorization. So it allows the principal foreign national to now have a dependent who can also work and help support the household. So that is an area that we see a lot of interest from new hires, and is definitely something where if a company is willing to support that, it makes the company much more competitive in the marketplace. The next topic is how to take your H-1B and get or other types of visas and bring yourself all the way to the green card stage. And so the path to the green card is really going to be the oftentimes deciding factor whether someone wants to work with your organization. They want to know at the beginning, are you in support of permanent residence or green card sponsorship? And if you have a policy in place or are open to creating policies where you do allow that to be an option, I think that is one of the best ways to remain competitive in the marketplace. Because if you're telling someone we do offer green card sponsorship within this time frame and this is what the expectation is, that will set you apart from other organizations that do not have a set program or do not want to support someone in the green card space. Because foreign nationals want to know that they have longevity here, that they're able to continue working in the space, that they're able to grow with the company. And at some point, if their non-immigrant category, whether that be H-1B or F-1 ends, they want to make sure that they've invested the time and the energy to be able to continue working here beyond those expirations. So different paths to a green card are really laid out based on the criteria for the role. The more requirements that are placed upon a role, the higher the preference, I should say. So Brian had covered the O1 visa category, and its equivalent on the green card track is the EB1. And so the EB1 is first preference. It's the most desirable because each month the Department of State will say who can apply for a green card and at which time. And the EB1 category, that first preference that you see here, is almost always current, meaning you can apply almost immediately and there's no wait period. So that is oftentimes the most desired, but again, one of the most difficult categories to be in because it does require you to be at the top end of your field, so top 5% of your field. The other categories, which are the second and third preference category, which are much more common, are those where most foreign nationals reside in. And as you can see on this chart, China, mainland, and those born in India have a wait period, and you see dates there. And you are not able to actually apply for the green card or even get to that stage until you have those dates appear on one of your forms. So if you submitted your ticket in line, best way to kind of describe this is going to a deli and taking a number. Until your number is called, you can't apply for the green card. And so some individuals, for example, in India, in the second-based category, if your number is December 1st of 2011 or sooner, you can actually apply for your green card application, which means if we're in 2021, we're looking at a 10-year wait for some of these individuals, which is, again, information that the foreign national will be well versed in and know, and they want to know how are you going to support them in this green card process. And if, for example, if they're in H-1B, can you get them to the point in the green card process where they can extend beyond that 6-year period because they are waiting for 10 years, for example, to actually finish the process. So again, these are pathways to a green card. There are definitely things that you discuss on a case-by-case basis, but to know that there's opportunities to change from a non-immigrant pathway to an immigrant pathway throughout your immigration process.
Thanks, Irma. And I think if we can actually just stick back on that slide, Brian, this chart, it's really confusing. A lot of you are probably looking at it and still trying to figure out what it is. I just want to explain that basically the chart on your screen, it comes out every month from the government, and it tells you approximately how long it's going to take to get a green card. And how long it takes is really dependent on two main factors: the country you were born in and the category that you file under. You know, do you file under extraordinary ability or do you file under national interest waiver? There's different processing times. And if you look at the chart on the top where it says employment based, and then if you go to the right, you see all chargeability areas except those listed. What that means is if you were born in a country that's not listed up there, and you see they list China, El Salvador, Guatemala, Honduras, India, Mexico, and the Philippines. If you were born in a different country, Canada, Venezuela, Russia, Australia, Bangladesh, then you're in that first row, that first column under all chargeability areas, and you see the letter C, 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 C. C means current. Current means there is no backlog. And really, when you look at this chart, you see that the backlogs primarily are for China and India. And so when you're hiring people that were born in China or India, and that's a really important part because a lot of people from China and India are Canadian citizens, but they were born in China or India. Be prepared that if you're going to go down the green card sponsorship route, it could be an extremely lengthy process. So I just wanted to point that out. And then one other thing, Irma, just quickly, you mentioned OPT, CPT, H-1B, green card. Could you just briefly give just a quick overview of what would be some of the financial obligations of a startup? I know a lot of startups that I work with are cost conscious and want to see, you know, what are the costs associated, and they hear, you know, some big numbers from people. But could you kind of break that down a little bit about OPT, CPT, H-1B, and then just very generally on green cards?
Sure. Well, in terms of cost, the most cost-effective process, that is almost always going to be the F1 category, because the F1 category, once you are hiring an individual that has OPT, that is something that they're coming to your company with. They've already applied for the work authorization document. They have the employment authorization document to present to you, and it's already in hand, which means there's no cost to the company to actually onboard that individual and allow them to start working. Whereas in an H-1B, there needs to be some proactive measures. You actually have to file a petition or an application with the U.S. Immigration and Citizenship Service, and you actually have to have approval before that individual can start working for your organization. And so the cost associated with that can be several $1,000s. We're looking at $2,000 to $3,000 in filing fees. If you want to expedite that process, the expedite processing can cost $2,500. And again, this is all just to get the person approved before they even start working. And then the green card path, that could also be challenging in the sense that depending on what the role requires and where that foreign national is from, you may be in an instance where you're filing a 3-step green card process versus a 2-step green card process. But the overall costs of the green card can be significant. For example, if you have someone that's going to be in that employment 2nd or 3rd category, and you need to actually test the marketplace and make sure that there are available opportunities for this individual without taking one away from a U.S. worker, you are spending money in the advertisement of the role and actually the application process. There are applications in which you have to pay, again, a few thousand for the actual petition in and of itself. So we're talking about fees that range from $5,000 to $10,000. And so it's very costly. So if you're the most effective of all of the cost effective of all of these options will be an F1. But to keep that person working for your organization, you have to look at how do I go beyond that OPT period and what do I have to spend to do that? And those are considerations that when you're working with a firm, they will kind of discuss that with you from the beginning and looking onwards to say, if you do decide to keep this individual, these are the costs that you're looking at. This is the investment that you're making in this individual.
Great, thank you, Irma. So we have about 10 minutes left. I have a couple questions, and Brian, I want to go back again to the L1 visa. We have a question here asking, what if you're an executive, a C-level employee, and major stakeholder, but you worked for the foreign entity through a management contract with a separate entity, or as a business, basically for tax optimization reasons. So we sometimes see this, but Brian, what would this entail in terms of an L1? Would that individual still be eligible? Could you talk a little bit about that?
Yeah, so if we're looking at, in the L1 context, a major stakeholder or shareholder is eligible for an L1. So that is something that is considered. Management consultants as well, depending on what the actual relationship is, and it takes a little bit of a specific assessment. But generally, if you are a stakeholder or have ownership interest or a shareholder, in the L1 context, this would typically be feasible.
Great. And then the next question is, if you have a U.S. citizen working in a foreign country and they marry a citizen of that country, does that foreign national spouse have an easier path to a green card if they were to both move back to the U.S. for employment?
So yes, I'll take this one. Sorry, Irma, if I interrupted you. So the short answer is yes. The longer answer is it still can take a considerable amount of time to, just because of processing and sort of the bureaucracy of the U.S. immigration system to get that individual their green card. But short answer is yes. And then actually a big part of that, I know we're running short on time, but I do just want to touch on it quickly, is backlogs at U.S. consulates and getting folks visas at U.S. consulates. So I just, again, that's a good sort of lead into just quickly touching on travel to the United States, right? So maybe we're getting through COVID, I guess we don't know. But, we do have consulates, U.S. consulates opening back up. And, we have folks you want to get an L1 visa, you want to get going in the United States and get folks here. The U.S. is now saying, okay, folks who are vaccinated, folks who take a COVID test within 1 day of traveling to the United States, you can come with a visa. But the big issue that we're seeing now is it's very challenging to get a visa. There are significant backlogs at U.S. consulates for even getting a visa appointment. So you might be eligible for your L1 visa, you might be eligible for an E2 visa, but you can't actually get it to come to the United States because right now consulates are backlogged into, some of them are March or April. Those are the good ones, right? So some of them are 3 or 4 months out for actually scheduling visa appointments for folks to come to the United States, get their visa and enter the US. Some, like consulates in Canada, are scheduling in maybe late August, September 2022. So there are significant backlogs at US consulates. So it is good news, again, that some people might be aware that the US rescinded most COVID travel bans that existed back in November. They instituted vaccination requirements and testing requirements for coming to the US, but it doesn't actually change a lot of the equation of getting to the US because folks can't get their visas, they can't get consular appointments. You can apply for emergency appointments or expedite requests, very unlikely to be approved. Those are reserved typically for humanitarian situations or personal crises to get to the US, very ill, very sick, or perhaps a death in the United States, things like that. So we do have this extra obstacle now built in of trouble getting a visa to actually come to the US, despite the US being back open for the most part. and despite folks wanting to now enter the US. So those are just some things to keep in mind as well. I think we have maybe a couple more minutes, so if there's any other questions, I think we can answer those, but I did just want to touch on that topic very quickly. I know this PowerPoint will be shared as well, so do take a look at the slides about vaccination requirements, testing requirements. All of that's also on the CDC website and subject to change tomorrow. So obviously take a look at that when you're traveling to the United States as well. But did just want to quickly touch on a few of those items before we run out of time.
Yeah, and Brian, related to the emergency appointments, what I've noticed that I think is interesting is that during the heart of the pandemic, when everything was closed, we had a little bit better success, in my experience, getting emergency appointments. And now that they're all open, it just seems like there's just no appointments for months, and getting the emergency appointments seem to be even stricter, because the embassies are just saying, go on our website and pick an appointment, and you go on the website and the first appointment is in April or maybe even September. And so, you know, emergency appointments, it's an option, but like Brian said, it's really, really tough right now. Brian, I guess since we just have a few more minutes, why don't you just touch upon, you get the L1 approved, you get the visa from the consulate, you're ready to hop on your plane. What are the last few things you need to do before you actually can enter the United States?
Yeah, sure. So, you know, in this new, it's probably going to be the new normal, you know, this COVID world. For entry into the United States right now, and this is going to be for anyone that is not in Southern Africa. Right now, for those present in Southern African countries listed on the screen here, you are not permitted to enter the United States, no matter your vaccination status or anything else, if you've been present in one of those countries within 14 days of entry. For everybody else, there is a requirement that you are vaccinated. And that you're vaccinated with either a CDC or World Health Organization approved vaccine. And for most of those vaccines, it means fully vaccinated is, you know, more than 14 days from whatever the last dosage is in that vaccine regimen. So that is the first thing. There are some exceptions for children, for folks from countries that have very low vaccine accessibility, but those exceptions are few and far between. Just generally, you should understand there's a vaccination requirement to enter the United States. The other item that's in place is, and here's a list, as of today, here's a list of the accepted vaccines for entry to the United States. The other requirement is obtaining a negative COVID test within 1 day of travel. So this is considered what's a viral test. It doesn't necessarily mean a PCR. It can be a rapid test depending on the type of test that it is, but you will need documentation from you know, the agency or doctor, whoever it might have been, that issued the test and can verify the results. So you will need that documentation as well in order to board a plane, in order to board a flight to the US. Again, all of this is CDC requirements on the US CDC website. And again, you know, I put, you know, December 16th, 2021, it's these vaccines. December 17th, it might be different. So always very, very important to take a look at the CDC website and those requirements. And again, you know, with Omicron and with, you know, potentially surges in places, we can't say that other travel bans might not be put in place, you know, when we get into January. It's all speculative. We just don't know what's going to happen. But for now, this is sort of the lay of the land in terms of COVID-related travel to the US and those vaccination and testing requirements that exist.
Yeah, and there are some exceptions to the vaccination requirement, but they are very, very limited. Primarily for children under 18 and for individuals that are from countries that have per the CDC, a very low rate of vaccination. Where you have trouble and where I'm having trouble is with people like Russian nationals, because the vaccination in Russia is not accepted and they don't qualify because the country has a high enough vaccination rate. And so there's some tricky things with certain people from certain countries, just to keep in mind. And like Brian said, who knows what it's going to be tomorrow. But listen, it's 11 o'clock. Thank you all so much for listening and joining us today. Brian, do we have our contact information?
We do, yes.
Perfect. So feel free to email us if there's any questions you have, and I'll turn it over to Michael for some final thoughts. You're on mute.
Thank you. One quick additional question. What are some best practices for startup teams to plan ahead for this entire process in terms of allowing enough time in advance to accommodate for the backlogs?
So in terms of the delays at the consulate, that's a really tricky one because there's not much we can do. A lot of it is out of our control. But you want to work with an immigration attorney to at least, there's typically two parts to the process. One, you file the application in the United States with U.S. immigration, wait for that to get approved, and then schedule the appointment at the embassy. The part with U.S. immigration, that's operating normally. And so you still can go through, file, get that approval, and then for the next step of applying for the embassy, there are a few little tricks like Brian mentioned, perhaps looking to go to a different country, not the country you're living in. Perhaps you qualify for an emergency. But the thing is, you can't even make an appointment until you get that first step approved at U.S. immigration. So you want to move forward with that. And by the time that's approved, maybe an appointment slot does open up. And then it's like how it is with a lot of things where there's no slots and then all of a sudden someone cancels and you log in and all of a sudden an appointment just opened up. And if you don't take it, it will be gone, in seconds or minutes. So it's one of those games to try to get an appointment.
Okay. So it sounds like allow plenty of time in advance, plan ahead, start the process early, because there are definitely some delays and backlogs involved. Great. Thank you very much, Aaron, Brian, and Irma, for that very informative presentation. Any final thoughts you would like to share?
No, thank you everyone for joining. Like I said, we're an email away if you want to run an idea by us, if you have any further questions about your company or about hiring foreign nationals, and we're happy to assist.
Okay, great. Thank you everyone for joining us today. We hope you found this presentation very informative. Thank you.
Thank you.
Thanks everybody.
Everyone.
Have a good day.
Bye-bye.